it's our live broadcast of the presidential election petition court's decision of course, the presidential elections that are held in this year. Well, just for your information, we have a dedicated stream for this particular broadcast, and it's, of course, on channelstv.com's website page, YouTube page. You can just go ahead and share that particular link with your people. Already we have almost, well, more than 7,000, almost 7,500 people watching right now. You can do some other people a favor who need to get a better understanding of what the issues are. But right now, let's begin that broadcast by hosting Norison Quakers with us here in the studio, who is a senior advocate of Nigeria. Thank you so much for joining us today.
My pleasure.
You know, one of the questions Bukola, my colleague here, and I were considering the other time earlier on the show was, what makes this particular one unique? What makes this peculiar? Since the First Republic, we realized that the first time we didn't have a contested presidential election was in 2015. But now, what makes this particular episode, if I can use the word, unique?
Very, very interesting question, because I've had time to also reflect on this and to be candid with you. What I see creating the tension and the conflict is that you have three generations. You have the analog generation, you have the hybrid generation, that's the generation you can describe as analog and digital, and then you have the fully digitalized generation. Now, because of the exposure of the digitalized generation, and many of them are just coming in to vote for the first time in this presidential election, and if you look at it in that context, you see that many of them rallied around a particular candidate. And that is what is creating the tension. And they believe that that particular candidate should have been declared as the winner of the election. So essentially, you have a group of persons who also, for a long time, have been advocating for change in the Nigerian environment. Many of them also queued behind the NSAS. So you have a lot of them now looking at this, the outcome of the election. So the reason why you have so much tension is as a result of this new generation. Now, the hybrid, those who are in between the analog and the digital, they are there to either pacify or create some sort of equilibrium. So you have the system that has been heated up as a result of this. This is not the first time that we'll go to the polls, and this is not the first time an outcome is being challenged. But you now have a generation that is not really keen. They've lost confidence in the judiciary in relation to certain pronouncements or certain things that have come out. And they're not ready to persevere and be patient. Now, because we operate a multi-party democracy and constitutional democracy, if you lose, right, there is always a window. Incidentally, because right now we're saddled with the presidential, the outcome of this, one way or the other, a winner or loser, one person will still have to go to court. And the last level for this is actually the Supreme Court. So I don't see, to be candid with you, the tension is so, you can feel it in the air. I recall that before now, some of our friends have cause to travel out of the country because they envisage crisis, which is not necessary. I believe we should take a cue from Kenya. Presidential election in Kenya was concluded within 14 days. And if you recall, I think the Chief Justice then, Martha Koome or so, in her statement said, deliver the judgment and fuller reasons to be given within 30 days. All right? Now, in one of the things that she said that really struck me is that the outcome of the electoral challenge is as a result of the failure of the umpire to do what the umpire ought to have done. Could that be likened to Nigeria? Because their constitution is similar to ours. The outcome of their election is also similar to ours. So where did we get it wrong? So the tension or the palpitation is as a result of this new generation. Perhaps so we need to strike a balance.
Yeah, perhaps one of the major differences here is our population is quite a huge one. And then the our interests are very, very diverse. But then, just as you noted, we have a very central population that's youthful. But then one of the other things about that particular one, before we go into the nitty-gritty of the whatever it is that we need to discuss, is education or awareness or information. For instance, Mr. Falano, SAN, was quoted as saying that a host of people who are actually agitating about this particular decision of courts that we're waiting for, they are first-time voters. And consequently, if they feel that they've been hard done by, then as far as they are concerned, they have been hard done by. So in terms of education, in terms of awareness, so that expectations are managed, what have we missed doing? What do we need to do?
You see, the challenge is this: how do you inform, educate, and enlighten a group of persons with a mindset? It is difficult to enlighten because whatever you say, from whatever perspective that you convey it, you will be seen to be jaundiced. And so the challenge now is, how do you enlighten this group to the point of appreciating what the issues are? For instance, election petitions are determined based on facts presented by respective parties. And what the court does is to simply apply the law to those facts. A decision will come out one way or the other based on what you put forward. Justice Ilori of blessed memory, I remember many years ago, said to us in open court, he said, cases are won or lost in chambers. In other words, whatever you present is what the judges will apply the law to or the rules to. You cannot present a clear case applying the facts, even though some of our colleagues, even of the inner bar, are of the opinion that the late sage Chief Obafemi Awolowo said one of the reasons why he quit legal practice is when he woke up one day and realized that you cannot predict the outcome of a case, applying the rules, applying the law. And so he just felt, no, at this point, there's really no need. But some of us we're still hanging in there because we believe that if I lose in the High Court, where only a judge hears the matter, I take the matter to Court of Appeal. 3 justices of the Court of Appeal will hear the matter. If I lose at the Court of Appeal, and then I end up in Supreme Court, where 5 justices of the Supreme Court will look at the same matter and come up with one judgment or the other. Now, at the end of the day, now, mind you, we live in a human society. People are bound to make mistakes, and that's the essence of having the appellate court to reverse. So enlightenment starts first by, we don't really have a reading public. We also do not have a public that is well informed. But this generation, the digital generation, is well informed. And I feel that there should be an application of that information to what the law is. What is the law? What are you meant to place before the judges that will determine what the outcome will be? There's hardly anything that we're going to discuss that is also not in the Constitution, that is also not in the Electoral Act. What is the umpire expected to do when I put myself forward to seek for elective office? You have what they call the filtration system. They need to look at documents I'm bringing forward, filter it, determine whether I'm a suitable candidate for the election. There are constitutional provisions that must also be considered. When you do all of that, there's actually no need for a participant, a party who contested the election, to be challenging those very things that INEC ought to have done. And that's the shame of all of this. So for me, the enlightenment starts by those who are either queuing up behind a particular candidate to pick the law, apply the law to the facts that have been presented, and then you can now simply say, okay, this might likely be the outcome. So if the outcome is one that is not in line with your expectation, what do you do? There's a higher court. Let the Supreme Court finally determine it one way or the other. So basically, you have 2 sides to this case. Is either a winner emerges, and when the winner emerges, there will also be a loser. So by and large, it can also be tested upstairs. You have cases. 2 days ago, I sat and I said, we live in a litigious environment. And that's one of the reasons why I also commend the immediate past president of the Federal Republic of Nigeria. If there's any political or a politician or a candidate that has attempted to use the court to seek redress for the actualization or realization of his mandate is the immediate past president of Nigeria. His name is in nearly all the law reports for the period he contested for the election. For that period, he was always going to court, at the tribunal, at the Supreme Court. So if a man had taken that step all this while, it gives one the courage to say, there's never an end to this. If you look at the three major candidates that we have today, Atiku Abubakar, Peter Obi, and Ahmed Bola Tinubu, Peter Obi is litigious, goes to court regularly as governor. Atiku Abubakar, as vice president to Obasanjo, while he was still serving as president, also went to court. Now, I have not seen any case where Tinubu went to court to challenge a reversal of a decision that was actually made against him. Now, he has always been the incumbent. When he was governor, all right, you had the opposition taking him to court. So he's again a man who is also used to the court. Now, recall that while he was governor of Lagos State, he sued the then president in relation to the local government and a number of other cases as well. So these are men who are used to the court system. So for me, I feel that the followers of these men should also queue up behind them to say, look, if these men do not believe in self-help and to a large extent flown the kite of confidence in the judiciary, why must I do otherwise? And that's where the problem is.
And, you know, Senior Advocate, you have rightly observed, even though you appear to belong to the older generation, that, this digital generation, that this digital generation,
yes,
they are quite educated.
Absolutely.
If you visit, you know, the social media space, they have dug up past cases. They are quoting Section 134 of the Constitution, and they're so invested to the extent that, you know, they're expectant that the judgment will go this way or nothing else. Do you sense, you know, the political party candidates, their leaders now, you know, being temperate enough to tell them, look, whatever the outcome of the judgment is, that is the way we would go, or we would go to the Supreme Court. But, you know, let's keep the peace. Do you sense that? Do you sense that messaging?
I think so. Consistently, I recall that Peter Obi has always spoken to his supporters, and the same thing with Atiku Abubakar. Now, Bola Ahmed Tinubu, you can also see it. Now, judgment is to be delivered today. He's not in any frenzy. He has traveled out of the country. Now, the only thing that gives some of us worry is when you deploy the instrumentality of state authority or state power, it gives an impression. And that is something that people like us are not comfortable with. Anyone who is discerning can tell that the situation is tense. And so you cannot afford to heat up the system. Now, the digital generation, they've done their own research. And like I said, sometimes there are things that you cannot see that the justices will see. Do you know that you can actually lose a case on just one technical ground? And I'll give you an example. If you're meant to have filed a particular process, and for some reason you defaulted in filing that process, right? And the followers will not know that that particular process is missing. When the justices sit down to look at it, and that particular process is not there, or maybe a ground of a petition is missing. Now, on your part, you think everything has been done. There was a particular case that I did a while back. The plaintiff failed to endorse his writ. We had gone very far in the matter. The matter was adjourned for judgment, only for his lordship to invite us into court yet again and pose that question to us, that we should address him on the issue, whether his court has jurisdiction. Now, plaintiff believed that he had concluded his matter, only for the judge to draw our attention to that irregularity. On that basis, his case was thrown out.
Wow.